and my name is Michael Sears. I'm from an agent in Gravesend in Kent called Seeley's Walker Jarvis. With me is Steve Lane from Robinsons, who have two branches, one in Dorking and one in Reigate.
Hi Michael, nice to be with you.
Okay, today we're going to have a look at the override legislation that covers commercial property, the thing that differs commercial from residential. What difference to commercial lettings does the Landlord and Tenant Act 1954 make?
The Landlord and Tenant Act 1954, it's really the security provisions that do govern whether tenants in commercial property have the right to renew their leases or not. Now, most people watching this video will probably be familiar with the residential side. They do also rely on the same act, but they usually fall under Part 1 for the residential, whereas today we're looking at Part 2, which governs the commercial lettings.
And Steve, what makes this bit of legislation so critical when it comes to commercial lettings?
Most tenants these days, as we probably all find in the marketplace, only want to take a commitment for a shorter period. Traditionally, commercial leases used to be 10 years, 15 or 20 years. The idea is that if somebody was a shopkeeper with a commercial lease on their shop, at the end of the term they had a livelihood, it was their business, it was their life, and they should have a legal right to extend their lease unless there were particular grounds of recovery. What we've now found, a little bit like a seesaw, is that we've got a situation where tenants don't want to give the same length of lease commitment, and therefore landlords are saying, well, why should I give an indefinite term to them? So it's been some form of adjustment.
And Steve, in practice, how does this work?
The main thing to remember is that any lease that a tenant commits to is ordinarily going to be a protected lease, and therefore a lawyer will provide a lease with the tenants having the protection to renew almost indefinitely under certain legal grounds. So what they've got to remember is they've got to what I would term opt out. So they opt out of those rights, and therefore whilst it's all dealt with by the solicitor, it is imperative for the agent and the tenant to have this agreement that if the tenant wants a shorter term letting, they must opt out of the lease. And it's a right that the tenant is giving up and forfeiting, as opposed to a right that they would otherwise under prescribed measures have.
Is it the agent or is it the solicitor that deals with these processes?
It's the solicitor that will deal with the process, but it's for the agent in their heads of terms to ensure that the solicitor has got those instructions. And I would say that's implicit in any heads of terms to make it very clear whether a letting is to be excluded from the Act or included. It will be the solicitor's job, and I would always say that any agent shouldn't get involved beyond heads of terms. The Section 38A rights are the provisions that do allow a landlord to bring a tenancy to an end if it's a protected lease. They're in a prescribed form, and it's always something that a solicitor should deal with. And certain rights would include if a landlord wanted to occupy the premises for their own use at the end of the lease, they'd have the right to terminate. If the landlord wanted to redevelop the site, they would have certain rights. And also if the tenant hasn't been playing fair, they might have not maintained the property in suitable order, or they might have had persistent rent arrears, then those would be grounds that the landlord could recover. But on the basis that most landlords for short tenancies want to have a tenancy rather like an AST, where it's for a set term and then it comes to an end, or has a right to come to an end, then it's important to ensure that the solicitor proceeds with that. There's a certain procedure that again the lawyers will deal with, where the lawyers will have to agree within the lease terminology and referencing that the lease is excluded from the Act. There's certain warning notices that have to be given to the tenants at least 14 days before the lease commences, or if you're in a rush, they would do a statutory declaration. And other grounds to ensure that explicitly the tenant before they enter the lease is accepting what they give it, the rights that they're giving up.
And Steve, what's your advice to the agent in terms of trying to avoid some of these pitfalls?
I think the point is to have the default situation of anticipating that any short letting must be outside the Act, and that they must instruct the solicitor clearly on that. Because if there's an error, because you're opting out, the solicitor may have justification to consider that any lease they're granting has protected rights, unless you as the agent say otherwise. So from a Propertymark point of view, we're very keen to ensure that everyone is aware of the pitfalls.
That's superb. That's great advice. Thank you very much, Steve.
Thank you. That's been helpful.